Hello and welcome to this Fox Nation special. I'm Greg Jarrett. Alex Murdaugh's appeal for a new murder trial denied after a full-day battle in court. Attorneys for the former South Carolina lawyer convicted of killing his wife and son petitioned to get a new trial, alleging the clerk of the court tampered with the jury and altered the outcome. Well, yesterday, a judge questioned the jurors and that clerk, Becky Hill is her name, to see if there was enough evidence to uphold those allegations.
I simply do not believe
Hello and welcome to this Fox Nation special. I'm Greg Jarrett. Alex Murdaugh's appeal for a new murder trial denied after a full-day battle in court. Attorneys for the former South Carolina lawyer convicted of killing his wife and son petitioned to get a new trial, alleging the clerk of the court tampered with the jury and altered the outcome. Well, yesterday, a judge questioned the jurors and that clerk, Becky Hill is her name, to see if there was enough evidence to uphold those allegations.
I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court.
Well, those were the words that Alex Murdaugh did not want to hear, so he's back in prison, continuing to serve his life sentence. But his defense team says the fight is far from over.
Who wins today is just one step in the process.
With the facts resolved, the only issue is what is the law? And as Judge Toll said, that is unsettled. This is not, it's going to go through the appellate courts, and we feel strongly that we'll win.
Well, it's not quite unsettled, but the question really is what happens next. Here now to talk about the case, what happened yesterday in court, three individuals who were there. Lauren Taylor joins us, criminal defense attorney. Seton Tucker, who is host of Impact of Influence podcast, and Will Folks is with us, founding editor of Fitz News. Thank you very much, all three of you, for being here. And importantly, I want to emphasize you were in the courtroom. I wasn't. But I've been a lawyer for more than 4 decades, and this seemed to be an uphill battle for the defense. But I want to get your initial impressions of what you saw in that courtroom yesterday. And Seton, let's begin with you.
Well, I think when Juror Z testified, I think it was a wow moment. We had previously seen her affidavit, but seeing her say that she was influenced by Clerk Hill's testimony or comments was definitely a wow moment.
Yeah, I think it really was. And I was, in addition to watching what was unfolding inside the courtroom, I was monitoring social media. And the universal opinion, Will, was this is it because of Juror Z saying, oh, yeah, I was influenced, that Murdaugh would get a new trial. And I thought to myself, nah, I don't think so. What were your thoughts?
Well, you're exactly right there at the beginning. When we first heard that testimony that Seton was referencing, everyone immediately thought, well, that's it. We can pack this show up and go home and get ready for this retrial. And I think the thing that was interesting about it as well was, this was the very narrow standard that former Chief Justice Jean Toll had established 2 weeks earlier at a status conference. Not only that there was tampering, but that the tampering had an impact on the verdict. And so I think to see that bar cleared so early in the process by a witness that everyone found very credible, I think a lot of us thought that would be enough.
Did you think so as well, Lauren?
I did. It was really interesting being in the courtroom. Obviously, Justice Toll had questioned, I believe, one previous juror on that Friday, but Juror Z was the first juror that the courtroom got to see questioned yesterday, and by all accounts, her testimony was jaw-dropping, and I think a lot of us in the courtroom were shocked and, were eager to kind of see what else she had to say, and I think that developed as the day went on.
So, Lauren, let me just stick with you for a moment since you're the lawyer here. And the judge laid out what she thought was the law. There is some uncertainty in it because there are conflicting cases. I wouldn't call it unsettled, but conflicting law. And she laid it out. She said two things have to happen. The clerk has to have made an improper comment or comments to the jury. And the judge found she did, called them foolish and fleeting. But the second one was the trouble that the judge had getting over, that the improper comments by the clerk actually influenced the verdict. Those are the words of the judge reciting what she thinks is the law. And she said, no, the clerk's comments did not actually influence the verdict. And yet you did have that singular juror, Juror Z, as she was known, who said, well, yeah, it did influence me. It made me think that the clerk was telling me that the defendant was guilty. So I'm trying to figure out what you think of the judge's interpretation of the law in the face of the testimony of Juror Z.
So this case, obviously, the defense and the prosecution are citing some of the same cases, and they're actually citing them in correspondence with each other. So Green is the case that Justice Toll is a South Carolina case, and that she has decided is the law she is going to apply, and that is the standard that you set forth. That there has to be inappropriate contact, and that contact has to rise to a bias level. It's also important to note that she expressed that the burden of proof is on the defendant in this. If she had chosen to follow the Fourth Circuit case of Remmer, that would have been a lot different of a standard of proof, and it would have been shifted more towards the state to say, there is no bias here. I think also important to note with Juror Z, even though, those in the courtroom actually saw her testimony and those that were watching at home heard it, later in the day, after she was excused, her attorney did attempt to proffer an additional affidavit, and that was really not what Justice Toll was interested in at that point. And I think that might have further hurt the credibility of Juror Z, because in Justice Toll's opinion, she had a chance to sit on the stand. She was asked questions. She had a chance to express anything that she might have been confused about while she was on the stand. And then to supplement later with an additional affidavit seems like additional, I believe she said, bites at the apple. But then in the same tone, Dick and Jim's argument was, I believe, the way she was questioned. She had provided an affidavit about 6 months ago indicating that it was other jurors who were actually pushing her towards voting for guilty and influencing her verdict, which, as we know, that is a totally different standard and is much more allowed than any kind of court official or clerk of court having any kind of conversation or impact on the jury's deliberation. So once she wrote that affidavit and was questioned about it, she essentially differed in her statement on the stand than what was in the affidavit. The judge tried to remedy that, and I don't know if you want to say Mr. Harpootlian stepped in it, but as soon as he proffered that affidavit up, and I think Creighton Waters was going to use it for impeachment purposes, but as soon as that was brought up, I was like, no, let's not bring that up. It's not great for the defense. But it was important because then Justice Toll, had that curing question of, is it more likely that your affidavit is the truth than, which states that the jurors were influencing her verdict, than Becky Hill? And her answer to that was yes, and then she was excused. Dick asked for her to come back out and have follow-up questions, and Justice Toll denied that. So I think that was the part that everyone was just a little, it made us kind of recoil because it seemed like she had more to say. And I think everyone in that courtroom was interested in what maybe that subsequent affidavit detailed. And also, if she had any more details she wanted to share on the stand, I think everyone was waiting with bated breath to hear.
Yeah, I mean, look, the closest you'll ever get to the truth about jury tampering occurs on literally the day of the verdict, when the guilty is read, and then the judge polls the jurors individually, goes through each one of them. Juror number one, is this your verdict? Yes. Do you agree with the verdict? Yes. And the judge, the trial court judge, back then, I believe it was in March, went through each and every one of the jurors. They all agreed, universally. So if there was a time of undue influence that, Juror Z thought, well, this really isn't my verdict, it would have been stated then and there. I want to play a clip, Seaton, before I get your reaction. Here is the questioning of Juror Z. You won't see the face of this individual, but here it is.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case? Want me to
Yes,
read it
ma'am.
again?
Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that, that's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right, now, Seaton, I didn't have the benefit, as you did, of sitting in the courtroom and watching Juror Z's facial expressions. But as I listened to it, I wasn't buying it for 1 minute. The long, agonizing pauses, the uncertainty, and what the judge later said was Juror Z's ambivalence. But you probably have a much better take than I do since you were there. So tell us what you saw when all of that was unfolding.
Well, my opinion is she was giving thoughtful answers. She was listening to the judge, and she was really trying to make a thoughtful answer to her question and making sure she understood it fully. I found her to be credible. I think, to me, the big question is, this is what she thought now, and is she having some sort of buyer's remorse for what the verdict she rendered, almost a year ago? And I think that's why Justice Toll brought her back in to talk about this affidavit and say, which is it? Now, I think it can be both. I think she could have been influenced by the comments made by Becky Hill, and I think she could have also, I think she could have also been pressured by other jurors. So that's the question, and I wasn't quite sure whether she was having buyer's remorse for being pressured by other jurors.
When you
Which doesn't matter.
read the affidavit, though, it sort of seems like she's saying, well, it really was the other jurors who were pressuring me, which, by the way, is normal.
But can't you have both?
Happens in almost every case. In the cases I
Exactly.
tried, I talked to the jurors afterwards, and there was quite an argument, and it was pretty tense, and anybody who's seen the famous film 12 Angry Men knows just how hostile it can get. But that's not grounds for a new trial, right?
No, absolutely. She could have felt pressured, but she could have also been influenced by Clerk Hill's comments.
Yeah. Will, what was your take on that
what was
as juror? Go ahead.
But what was her opinion? Justice Toll brought up the fact that this is very unusual, that this hearing is taking place almost a year after this verdict was rendered. And typically in these type of situations, it happens either during the trial or shortly after the trial. So I think possibly Justice Toll was trying to get back to what was happening at the time of the verdict, not what is happening now.
Will, as you were watching the back and forth between the judge and Juror Z, who's claiming, jury tampering that unduly influenced her, what were you thinking? Did you believe her?
I did. I found all of the jurors' testimony credible, whether they said that they heard Becky Hill making these comments or whether they said they didn't. I didn't find any of the jurors to be lacking in credibility. I think the only person who testified yesterday lacking in credibility was Clerk Hill. But going back to what you and Seaton were discussing as it relates to this standard that the defense had to meet in this hearing and the interchange between Justice Toll and Juror Z, I think the thing we need to think about is that, two things can be true at once here. You could have her say that it was pressure from the other jurors that ultimately pushed her across that finish line to decide that she was going to vote guilty, but that Hill's comments could have influenced. And if you go back and listen to the way that Justice Toll asked the question, she didn't ask the question, did this decide your verdict? She asked, did it influence? Did it impact? And so I think that that's a key distinction, and I think we're really arguing two things that can be true at the same time.
Yeah.
I agree.
Well, it is not unusual that jurors after the fact, sometimes years after the fact, start dissembling their deliberations, reimagining them, to use a term that Seaton referred to, buyer's remorse. That's guilt sometimes, and they want a do-over. But, our system of justice doesn't normally work that way. I want to go right now to the next clip from yesterday. This was incredibly important. This is the questioning of the clerk, Becky Hill, who is at the center of all of this, who wrote a book, and that's a whole nother can of worms there involving plagiarism and other accusations. And the defense theory here in asking for a new trial was, she was trying to engineer a guilty verdict because she thought a guilty verdict would sell more books. So here she is under questioning.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No.
All right, now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No.
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
So, Lauren, it struck me that the judge wasn't really buying most of what Becky Hill was saying. And in fact, in her decision at the end of the day said, this was foolish and fleeting by the clerk Becky Hill, listening to the siren of publicity. I think I'm paraphrasing there. What did you make of Becky Hill's comments there? I mean, I got to tell you, I didn't buy anything she was saying because she's an admitted plagiarist.
Right, and I think that was the problem most of the public has with her. You know, the questions that Creighton Waters did a really good job, I think, of leading her down a path of least trouble, maybe we could say, because, you know, she has some charges that are more than likely going to be stemming from this entire incident. So watching her testify yesterday and watching the direct examination that Creighton did and then the cross-examination that Dick did, I think you could kind of feel the tension between Becky and Dick Harpootlian. I think, you know, he's made her life really uncomfortable over the last few months. And, you know, for lack of a better word, you know, if she didn't do these things, we wouldn't be here. And I think it's also important referencing, I know we're talking about Becky Hill right now, but the day started. We are here to address potential jury tampering, and the day started by having the jurors watch Juror Z's testimony on court TV. So, like, why can't we get it together in South Carolina? This is the exact issue we're here to discuss today. And, you know, we couldn't even get bailiffs in the jury room to ensure that they weren't on their cell phones. And as far as the jurors, you know, veracity of their statements, you know, after Juror Z, as they started coming out, you know, she started adding the question to their 7 questions, I believe, saying, did you watch the court TV feed, or did you have your cell phone out? And one after another, they were all saying no. And I was like, okay, well, somebody's going to have to cop to having their phone out, because clearly the bailiff saw it. But I think Becky Hill, had the most damage that was done to Becky Hill yesterday and her credibility was done by Justice Toll herself. The actual written record, you know, we can get into a he said, she said with jurors that might have heard comments in passing in the hallway, which I think is kind of what Creighton was getting towards, that, you know, she might have made statements to a bailiff, but it wasn't intended for a juror to overhear it, and it might have just accidentally happened in the passing. And this being such a long, you know, trial, there are going to be contact issues that come up. But I think, you know, with the record being that what it was, and when Judge Newman, you know, you mentioned juror issues are brought up during the trial. Well, it was brought up. Judge Newman, you know, actually said on the record that he was not pleased with his clerk of court, Becky Hill, questioning a juror before he could. And that is in the record. So when she was denying that under questioning from Justice Toll, you know, I was sitting there thinking, are we going to see a perjury charge come out of this? Because, you know, I think Justice Toll gave her several chances to correct her statement, and even said multiple times, I'm reading from the record and the transcript, and this is what the judge said. So, you know, correct me if I'm wrong. And there, you know, everything was not Ms. Hill's fault. It was misunderstood. She even made the comment, you know, that she didn't make very much money from this book. Well, Mr. Harpootlian got out that she made almost $100,000. That might not seem like a lot of money to some people, but the average citizen of Colleton County, I believe, is a median income of $37,000. So, you know, this is a substantial amount of money. And as far as the juror and her influence in it, I believed Juror Z, and I think she was nervous from the enormity of the situation, and she was really thoughtful in her answers to the justice's question, and almost nervous, I thought. But I also agree with Will and Seaton. I found all of the jurors to be credible in their testimony.
Yeah, before I play a clip of Dick Harpootlian cross-examining the clerk, Becky Hill, that was something to witness. She's in a world of trouble, isn't she, Seaton? You know, not only could she potentially, as Lauren pointed out, be charged with perjury here, but there are 2 pending investigations right now of her. And among the allegations that they're looking into is obviously that she used her position in office to profit financially. She benefited from her office. Another is that she conspired with her son, who's apparently being charged with wiretapping. And then, of course, the principal claim here that she, you know, unduly tampered with a jury, and then, you know, toss in the plagiarism stuff, which is pretty reprehensible and ugly. How much trouble is she in, Seaton?
Well, I think she's in some big hot water. I mean, there are these 2 pending ethics investigations, which what I've been told is the Ethics Commission, they have the ability to fine and reprimand, but I think the investigations that are happening with SLED are the real deal. So if any of these charges come to light that they are actually true, especially with the wiretapping, potential obstruction of justice, also misuse of public funds, which also have nothing to do with the jury tampering. So I think that's why Justice Toll was saying, this is not the trial of Becky Hill. Let's keep it focused to these jury tampering allegations. But she's definitely in a lot of hot water for more things beyond the jury tampering.
Yeah,
Yeah,
if she
and Greg,
were in
I
New
think
York
it's
and
important to
California,
note that. Oh, sorry.
Go ahead.
No, that's. I think it's important to note that the state needed Becky through yesterday. So they, Dick Harpootlian made a mention that she had spent, I believe, 4 hours with SLED preparing for her testimony yesterday. The state needed her. They needed to keep this verdict where it was and not to have this motion be granted. So I think we saw a lot of, hand-holding. I think their attitude towards Ms. Hill is going to change dramatically now that she is no longer needed to ensure the validity of this verdict. And I think we're going to see some repercussions hitting her sooner than later.
Yeah, it's like when the prosecution calls a jailhouse snitch. They hate the guy because he's a criminal, but they need him. So kind of felt like that. It's a great point you're making, Lauren. Seaton, you're going to have to leave us in about 4 or 5 minutes. So I want to play a clip here, and that is of Dick Harpootlian questioning the controversial Clerk Becky Hill. Here it is.
You either made it up or you're lying about it, about the reputation of people that can't defend themselves. They're dead. You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books?
Literary ease. Yeah.
What?
Literary.
Literary what?
The literary ease that you can take when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can lie. You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. You've conceded there are things in the books that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
Great cross-examination by Dick Harpootlian. The witness, pretty damn clumsy. It's not literary ease, it's called literary license, and it doesn't apply to a nonfiction book, which is what her book was. Maybe it would apply to a fictionalized version of nonfiction real-life events, but not here. So as she was sort of melting down under a eviscerating cross-examination by Harpootlian, Seaton, before you go, give us your thoughts about that.
Well, I'm glad you knew what the term was, because I was confused. I'd never heard the term literary ease. So I was confused about that and had the exact same thoughts that you did as far as, well, this is a nonfiction book. I mean, how can you just make things up? I mean, yes, she did bring up that she read newspaper articles and that sort of thing, and yes, you can rely on those, but it definitely was very damaging to her credibility to be admitting that she made things up and lied in her book. And plagiarized.
Yeah. But by the way, her book, Seaton, got yanked off bookstore shelves because of the plagiarism, right? I mean, she essentially stole passages, I think it was from a British journalist that was accidentally sent to her, and she had no conscience or qualms about just thievery, taking it and using it and putting it in her book. I don't know who her publisher was, but, most publishers who are responsible and thoughtful run these computerized plagiarism programs to make sure that people like Becky Hill don't, run a scam.
She was self-published. I think that was maybe part of the problem.
Self-published.
Yeah.
So no respectable publisher wanted to touch this thing. And I guess bookstores are now not selling it. They've yanked it off the shelves. And what, you probably can't even get it online, Seaton?
I believe it was only, I could be wrong, but I believe it was only for sale on Amazon. And last I checked, it was taken off of Amazon and is no longer available. But after the plagiarism, admitted plagiarism, it still was available for a couple of weeks on Amazon.
Yeah. Well, I didn't read it. Seaton, I know you have to run. Thank you so much for taking the time today. We'll continue with discussion of the rest of the panel. Now, I want to throw to the next clip. And apparently there was a clerk of the court in an adjacent county who was offering assistance during the course of the Alex Murdaugh trial. Her name is Rhonda McElveen. And apparently, she had conversations with Becky Hill. Let's listen into the questioning of McElveen.
Did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted
she-
to write a book, yes, sir.
Wanted to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis, in reference to the book? What would help the book?
A guilty verdict.
And
That-
tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay, well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books?
That would be the best way to sell books, yes, sir.
So, Will, Dick Harpootlian is a terrific defense attorney with a stellar reputation. He's not Clarence Darrow. You can't win all your cases. And by the way, Darrow didn't win all of his cases either. But he put on, especially I thought this was very effective, putting Becky Hill's friend on the witness stand and talking about, yeah, she wants a lake house and I got to retire. What did you make of that?
It was effective, although it cut both ways, in my opinion. I think that Ms. McDaniel Rhonda ended up being a fact witness for the prosecution. She was called as kind of a motive witness for the defense, talking about, the lake house and the financial motivations behind what Becky Hill was doing. But Creighton Waters, the lead prosecutor, was able to get in some very effective hits when he asked her, did you ever hear Becky Hill make these comments that several of these jurors have now attested to? And she said, no, I didn't. And in fact, he also pointed out that when Becky Hill was out for several days with COVID during the trial and Rhonda filled in for her, he kept pointing out, Rhonda was there more than Becky, and she didn't hear these comments. So I actually found that she kind of cut both ways in her testimony, helped Dick Harpootlian establish the motive, but also helped the state push back against the core tampering allegations.
Yeah.
I would agree with that.
Will, while I have
the
you here...
one thing that she did... Oh, sorry.
Go ahead. It's fine.
The one thing that Rhonda did, she actually brought some humor to the courtroom that was needed at that point. But the one thing she was able to corroborate that the defense got out of, I believe, I can't remember the juror letter. It was, I think, the second or third juror that testified, was that Becky Hill did give one of the jurors a ride home after the trial one night. That was something that Rhonda was able to substantiate, and something else that Becky also denied on the stand.
Yeah, I mean, you should never be giving a juror a ride home. If you're a clerk of the court or anybody who's associated with the court during the commencement of a trial. I mean, that's just an absolute no-no. I'd like to get both of your thoughts. Will, let me begin with you because, we didn't always see Alex Murdaugh in the courtroom, depending upon where the camera was trained. What was he doing throughout? Was he stoic? Was he animated? Was he writing notes? Was he talking to his lawyers? What did you see?
This was one of the few court appearances where Alex Murdaugh attended, and really he was kind of an afterthought at this hearing. There was so much focus on the witnesses, on the jurors, so much focus on Becky Hill's testimony that, Alex Murdaugh, I remember going over to the defense table during one of the breaks, and he's just sitting over there, literally nobody around him, kind of like an island in this courtroom. But, he did have some interactions with his attorneys, certainly seemed to be disappointed with the outcome, although I think his attorneys probably told him it was preordained and that it was something he should be expecting. This was a very high bar, but, we keep talking about these witnesses in this case and the testimony. And the one thing, and I want to get Lauren's take on this too, because, we spoke after this hearing, and you've got a juror saying, yes, this contact occurred and it influenced me. You've got at least two others corroborating that contact. And to me, even by the elevated standard that Justice Toll applied for this case, I don't know how they didn't meet it, especially when you factor in the total lack of credibility on the part of Clerk Hill, the star witness for the state. I mean, her credibility was shredded before this hearing even began, but it was absolutely eviscerated, not only by Attorney Harpootlian, as you just mentioned earlier, Greg, but by Justice Toll. Her questioning of Becky Hill was every bit as devastating as the defense's testimony. So, again, you put those two items on the scales, I just don't know how you end up with the outcome we ended up with.
Well, what about that, Lauren? The question as posed by Judge Toll, Jean Toll, who's been on the bench in some form or fashion 35 years before that, 2 decades as a highly respected, esteemed lawyer. I mean, she's the best of the best. And she put it this way: were the deliberations honest and free from outside prejudice that actually influenced or altered the outcome? Is that the right standard?
I think that's, what Dick and Jim are arguing is, she did not decide to hold Rimmer, which was a Fourth Circuit case, which South Carolina is in the Fourth Circuit. So I think they've laid it pretty clear path that they're going to take that avenue. Obviously, the federal side of things is going to take a lot longer than the state side of things. I agree with Will's statement, though. When we had the status conference, I believe 2 weeks ago, and Justice Toll indicated that she was not going to be holding a Remmer hearing. She was going to apply the law of Green. We all kind of thought, okay, this is going to be such an uphill burden for the defense to be able to show. But then, once she tailored the questions of the jurors down to, I think, 5 questions, once she asked that question of the juror and the juror answered that it did impact her verdict, I thought that Justice Toll might have tied her hands in that situation because she was so, precise in tailoring the questions of the jurors and also in outlining what she was looking for and what the standard she was going to be applying was. So once that was revealed, I think everyone was kind of left in a state of like, okay, well, now we have to have a second trial. Now, obviously, she indicated that she did not, find Juror Z's testimony to be, as credible, or maybe she was confused. I don't think she really dove into that as much. But, she absolutely eviscerated Becky Hill. And I think that is the issue here. We want our justice system, to encourage people to participate in juries. These jurors rendered this verdict almost a year ago, 11 months ago. I believe it was March 2nd of 2023. They are now being, driven in sled vehicles from Colleton County and taken from their homes. And most of them have been questioned by Dick Harpootlian, Jim Griffin, Creighton Waters, SLED. This is not a process that encourages people to want to participate in the jury system. So that is also at the forefront of her mind is how do we clean this up? Because that is, that's the delicate balance our judicial system is based on, is the jury system, and making sure, that we get people that not only want to serve, but understand the enormity of what we're asking them to do in the civil duties. So there were a lot of balancing acts that were happening there. But I do think we aren't left satisfied after the answer of that juror and after the cross-examination of Ms. Hill by Justice Toll.
Yeah, and look, as great as she is reputationally, Judge Jean Toll, Justice, I should say, because she's the former Chief Justice of the South Carolina Supreme Court, she's like the rest of us. We're fallible. We make mistakes, and apparently she didn't, request that the jurors who were waiting to testify be fully sequestered. They had their cell phones. They're watching the proceedings. They're not supposed to be watching on their cell phones. Take a listen to this. I want to play this soundbite and get your reaction to it.
I have to report this to you, and I'm very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors. The jurors' cell phones were not confiscated or taken from them. And they tune this thing in on court TV and listen to all of what just went on. So you may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record.
Full disclosure, I spent about a decade as an anchor on Court TV. It's not Court TV's fault, by the way. It is the court administration, and ultimately the buck stops at the justices, high deck. And, they should have confiscated those phones. But, Will, when that unfolded there, what were you thinking?
Well, it was funny to listen to the Chief Justice, when the microphone was on, say that she was not happy. I can tell you, being in the courtroom, watching her doing a little lip reading there, she was very much unhappy, uttered a few well-chosen Spanish oaths, as a matter of fact, as she was informed by the bailiff of what had transpired. But I think the real issue with that announcement was it goes to, again, the integrity of that jury process. I mean, here we are talking about a jury that was allegedly tampered with, that tampering allegedly it caused at least one of them to rethink their verdict. And here we are, before they're being brought out, one of them's testified, obviously ahead, and we're already having to question whether or not they're following the rules. So it did raise some questions. Again, though, I think when each juror came out, they answered the questions about the cell phones honestly. I think Justice Toll was smart to get that all on the record. And so I think it ended up ultimately not factoring into, again, the decision that she made and the events of the day, the narrative of the day. I think, again, the real takeaway from this was that we had some clear and compelling evidence of the standard that Justice Toll set. We had a totally disastrous witness for the state, and yet somehow Toll ended up siding with the state on it, which, again, I'm still at a loss as to how exactly that happened.
Before I play the last soundbite, which is Dick Harpootlian, the defense attorney outside the courthouse, pulling in OJ, I'm going to track down the murderer. The judge did say that she read meticulously the entire trial transcript, reviewed the exhibits, the evidence, and she said the evidence was strong and overwhelming. And indeed, for those of us who followed the trial, it most certainly was. The principal problem for Alex Murdaugh was that, his dead son essentially testified against him. What Murdaugh didn't know is that his son had activated his cell phone, and there was a video recording. And there is Alex Murdaugh at the scene of the crimes, roughly at the time of the murders, within 4 minutes. And he was forced, when he took the witness stand, which was foolish, he was forced to admit, for 20 months I've been lying about my whereabouts. I wasn't asleep on a couch. I've been lying to my family, my friends, the media, my lawyers. I've been lying to everybody. But now I want you to believe me. That's just a snippet of the compelling evidence against Alex Murdaugh. Go ahead.
And he continued to lie on the stand. That's the other thing, is that after all those lies he admitted to during his trial last year, he continued to lie on the stand and was caught in those lies on the stand. And so, look, this is one of the most contemptible figures in South Carolina history. He either did it, knows who did it, helped do it, or one of those things is true. Bottom line, if I were on that jury, I would have convicted him, no doubt. His guilt was proven beyond a reasonable doubt. But the process matters. Again, this is no longer about Alex Murdaugh. This is about waking up in a state where you have a right to an impartial jury. And I woke up this morning not really sure about that anymore. And I think that's the issue moving forward, is what is the standard going to be for jury tampering? How are we going to enforce it? And if this isn't a clear-cut case of it, I really don't know what is.
Yeah, we don't have enough time to play the last soundbite of Dick Harpootlian, but, you know, he is asked what he's doing. Do you have new evidence? And he says, yeah, we have new evidence of who committed the crimes. Do we have time for that? Okay, we do have time for that. Let's play it. Here it is.
I've asked about this before. You all have said that you're investigating. You said that you're investigating who might have actually committed these murders.
Yes.
Have you all found anything that you think you want to share with us?
We have developed some information. We want to get this behind us, and we'll be pursuing that in the near future.
About who committed the murder?
Who really did it?
You know, it does remind me, Lauren, of, you know, O.J. Simpson after his acquittal. You know, and I cover that trial beginning to end in Los Angeles. I've never seen such overwhelming evidence of guilt that O.J. Simpson murdered Ronald Goldman and Nicole Brown Simpson, his former wife. But then he said, I'm going to spend the rest of my life looking for the killer. Apparently, that killer must reside on a golf course, because that's how O.J. Simpson has been spending most of his time. So, you know, this is not the first time a defense attorney stands in front of the court. I'm going to find the real killer and prove my client's innocent. Is it, Lauren?
No, it's definitely not. However, I'm reminded, you know, of an old adage from a professor in law school that used to tell me, you know, I'd rather have 1,000 guilty men run free than one innocent man behind bars. And frankly, you know, our opinions on the guilt or innocence of Mr. Murdaugh were irrelevant to the proceedings that were taking place yesterday. We were talking about his constitutional due process rights. And I agree with Will. It is a terrifying thought to think, you know, that one of us could wake up in the morning and, you know, that 1% chance that maybe Alec didn't do this and, you know, he is being wrongfully convicted. It is a terrifying thought to think that that kind of fix could be in with the help of someone in a position like Becky Hill. And, you know, as Will said, although Alex is one of the most contemptible characters in South Carolina history, the man is convicted of murdering his son and his wife. Becky Hill was every bit as much hated in that courtroom yesterday as Mr. Murdaugh was. So I think it's really the integrity of the judicial system is what has to be taken care of here.
And I think that is a wonderful way to end our discussion. Thank you so much for being with us. Well, folks, Lauren Taylor, Seton Tucker had to leave earlier. You guys were terrific. Your insights are incredibly valuable because you were inside the courtroom yesterday. And of course, you were following the case from the outset. So thank you both for being with us.
Thank you, Greg.
We'll continue to monitor this case of Alex Murdaugh as his appeals move forward and unfold. Until the next time, thanks for joining us. I'm Greg Jarrett. Have a good day.